Kevin Durek for the state.
Griffin Hardy for Kaya Brown, who has been advised of the pending charge as well as the maximum penalty and waives a formal reading of the criminal complaint. At this time, I do not have a probable cause challenge.
And it is an arrest warrant, so the probable cause was already determined. The state has filed a motion to detain, so the case will be transferred to the district court for them to make a determination. The 10-day rule is March 1st. And so we'll get it sent over to district court. So the case will be heard by a district court judge, and there'll be a hearing to determine what, if any, conditions of release might be put in place in this case, sir. You can go ahead and have a seat. Thank you. Okay. Jason Marcus, SR 2022-569.
Kevin Durek for the state.
Griffin Hardy for Jason Marquez, who has been advised of the pending charge as well as the maximum penalty and waives a formal reading of the criminal complaint at this time.
Okay, and there was also an arrest warrant in this case. And the state has filed a motion to detain, so we'll get it transferred over to the district court. And the 10-day rule is March 1st. So the case will be transferred to the district court, and they'll have a hearing to determine what, if any, conditions of release might exist in this case, sir. So you can go ahead and have a seat. Thank you. Christopher Lovato. Is Christopher Lovato there?
Your Honor, we'll bring him in a little bit. Sorry.
Okay. Christine Castillo. FR 2022-173.
Kevin Durek for the state.
Griffin Hardy for Ms. Castillo, who is out of custody today and appearing via Zoom. She has been advised of the pending charges as well as the maximum penalties, waives a formal reading of the criminal complaint, and I do not have a probable cause challenge.
All right. Is there information about the defendant?
Good afternoon, Your Honor. I'm Martin Governor, Background Investigations. For the defendant, we located one misdemeanor that was DV related with a different alleged victim. That case was dismissed in 2018. One traffic bench warrant, none of which were failure to appear. And further, no felony history was located. And Your Honor, the defendant is present in court, so we recommend just the ROR book and release.
Okay.
Your Honor, the state filed a pretrial detention motion a little earlier today. So the state's position is the defendant should be held and that a bench warrant should.
So that does make things a little difficult since she is out of custody. So what are you requesting?
We're requesting a bench warrant, or that the defendant be given a turn-in date.
Yeah.
Judge, I think that Rule 7409 limits your jurisdiction to making a probable cause finding, and 5409 leaves it to the district judge's discretion whether to issue a summons or a warrant for the detention hearing. So I think at this point, it would make sense to just transfer it and let the district judge decide how to schedule either summons or warrant.
The problem is there's still an arrest warrant. So you all asked me to hear the case on the arrest warrant. So there's still an arrest warrant. She's not turning herself in on the arrest warrant since she's virtually appearing. There's no way to take her into custody since she's virtually appearing. So I think we have to kind of address that first, because the preventative detention motion has to do with, setting conditions of release, and we still have to address what I'm going to do with the arrest warrant itself. So I suppose we could leave the arrest warrant outstanding, but I don't know that that's really what anybody intended either.
Judge, I think when we had filed the motion requesting a virtual appearance, the preventative detention motion hadn't been filed yet, so that changed the circumstances. What I would ask the court to do would be to cancel the arrest warrant on Ms. Castillo's appearance today for the first appearance, and then leave it to the district judge to decide what to do in terms of scheduling the preventative detention hearing.
Yeah, I think that kind of subverts the idea, though, that if the state is indicating they believe that she presents such a danger to the community, to allow her to appear virtually today and cancel that arrest warrant seems counterintuitive to me. But I thought I remembered that the state even stipulated that I know there was more than one of these. So let me take a look briefly. There's just some emails. There isn't an actual pleading. State, what is your response with respect to the court's ability to issue a warrant given the unique posture of this case? Where's the defendant now? Or is he sitting in a vehicle? Where is she sitting in a vehicle at?
I'm at home, Your Honor.
State?
Yeah, I think actually Mr. Hardy is correct that it would be a matter for the district court, but I guess the state's position, it looks like we didn't respond to the motion to cancel the bench warrant. The state's position would just be to leave the bench warrant in place until.
It's not a bench warrant, though. It is. I mean, it's an arrest warrant, which is different than a bench warrant. I do see an email from a deputy district attorney that says we're not opposed to canceling the bench warrant, but a bench warrant is very different than an arrest warrant. So give me just a moment. I'll take a look at the rules and see what goes first. Because normally it's not an issue when there's an arrest warrant because the person has surrendered themselves to the court. The ability to surrender yourself to the court virtually is an interesting notion that I'm guessing the rules aren't going to provide for, but let me see. all I can see is if probable cause has been found, and probable cause was previously found by the judge that signed this warrant, the magistrate or metropolitan court clerk shall promptly transmit to the district court clerk a copy of the motion for pretrial detention, the criminal complaint, and all of the papers, and the jurisdiction shall then be terminated. So I don't think I have the jurisdiction to do anything, including address the arrest warrant that was issued, because once these were filed, the motion was filed, the way that folks wrote this rule, if probable cause exists, then it goes to the other court. So I don't think I even have the authority to do anything with respect to the arrest warrant. So the arrest warrant, I believe, stays in effect, but you certainly can get that clarified from the district court what they think happens. And I will just sign the order to transfer. Sign the order that gets it transferred. And you all can address with the district court whether a new warrant needs to be issued or if that existing arrest warrant that was signed by an unknown judge still remains in effect. So I agree with defense counsel that the way that the rule is written, it appears that it's anticipated that the district court will take it from here. Okay, thank you. I thought that they got reset so that they could come forward so someone told them what was going on. But that's... These are both reset, I was told. Well, that's what I thought, but that's not. Is that medical? So that's what I thought it is, but it's not. So on both of the two that weren't brought to the court today, that the state has found, or that the state has filed, then presumably the same process would go into place. That probable cause is found, and then I go ahead and transfer them. I'm uncomfortable doing that because it bothers me that the defendant doesn't get to come to court and get told what's happening. But based on that same logic and reasoning, what I have to do, because there is probable cause on one because somebody found it. I think maybe both were warrants, correct? No, one was a warrant, one was not. So I'm finding probable cause, and once I find probable cause, I sign the order, and the other one, there was already a warrant, so I sign the order, so they don't get reset, they just get set before the district court. You all agree with that?
Yes, Your Honor. State agrees.
I do share the court's concern about the fact that the defendant isn't present to understand what's happening, but I would defer to the court's judgment on how to handle it.
So on the record, FR 2022-618, Tobias Gutierrez. In that case, the state has filed a motion to preventatively detain, and in a previous case where the defendant was out of custody, the argument was made that once that motion is filed, I no longer have the authority to do anything beyond determine probable cause, and then I must immediately transfer the case to the district court. I reread the rule, and that does appear to be what it says. And therefore, I'll be consistent on all three cases before me, and instead of resetting it, which I previously said I would do, I'll order it transferred to district court and just ask that someone notify the defendant what's happening with his case. And I'll tell you also why I'm uncomfortable, because the first appearance isn't just to determine probable cause and conditions, it's also to make sure the defendant knows what they're charged with and that they've been provided a copy of the complaint and they know why they're there. So it makes me very uncomfortable the way that the rule is written, that my authority to do anything immediately ceases. But I do agree with defense counsel that that's what it says. So perhaps on a bigger scale, you all could revisit that with the folks who write these rules to make it clear. You know, it just is very concerning that defendants are being held in custody, not brought before a judge, not allowed to talk to counsel. I'm not suggesting the jail's doing anything nefarious, but it certainly is not what we intend, that folks get the right to see their attorney, be told what they're charged with, get a chance to review the complaint, and then be told what's happening with them. And we're skipping that step because of the way that I agree with counsel that the rule's written. So also in Joanna, Monique, Anaya, that one there was I also determined probable cause in that case, and that was a reset. So I will cancel the reset and the PC sound, and that the preventative detention motion filed and the order signed. Perhaps what we could do I am here tomorrow. If the jail's willing, we could have them on the docket just so at least somebody can bring them to speak to the public defender's office, even if I don't call the case. Perhaps the jail would still bring them to make sure they talk to counsel. And I'm not really sure how you all have access to folks in these days and the ability to talk to them either.
I think that makes sense, Your Honor. That's probably the best way to handle.
Okay, thank you. Okay, thank you. Okay, Brandon Lindsay, FR 2022-633.
Kevin Durek for the state.
Griffin Hardy for Mr. Lindsay, who has been informed of the pending charges as well as the maximum penalties and waives a formal reading of the criminal complaint. At this time, there is no probable cause challenge.
Is there information about the defendant?
Yeah, this is for
Background.
Brandon Lindsay, Your Honor.
This is Brandon Lindsay.
Yes, Your Honor. For the defendant, we located one juvenile contact, 5 misdemeanors with 1 conviction, 1 case pending with Judge Blair Rivera for battered domestic violence, criminal damage to property under 1,000, currently booked on a conditional release hold. There's a conditional release hearing scheduled for February 16th. 8 bench warrants, 7 of which were failure to appear, 7 felonies with 4 convictions, as a misdemeanor.
I'm sorry. I apologize. I just realized that I saw the interpreter and I thought I grabbed the other stack, but I just realized this is a preventative detention. I'm really sorry. So the state did file a motion to detain in this case, and since there is probable cause, we'll go ahead and get it transferred. I'm sorry, background. Okay, so I was trying to do two things at once. I apologize. The interpreter is on the line, so
Your Honor,
so if
this
we
is the
could-
interpreter. Can the court hear the interpreter?
That's what I was trying to do, and I thought I just picked up the wrong stack again. So I will find my little, there they are. So yes. I apologize. I thought the clerk had asked me to, when I was ready for you to call you, so I'm sorry to keep you waiting. So Victor Batista Martinez, SR 2022-620.
Víctor Batista Martínez, T4FR 2022-620.
Kevin DeReich for the state.
Kevin Direct para la Fiscalía.
Griffin Hardy for Mr. Bautista Martinez.
Griffin Hardy para el señor Bautista Martínez.
Mr. Bautista Martinez has been informed of the pending charges as well as the maximum penalties and waives a formal reading of the criminal complaint.
Al señor Bautista Martínez se le ha avisado de sus cargos y las posibles penas y renuncia a una lectura de cargos formal.
At this time, there's no probable cause challenge.
En este momento no se opone al motivo fundado.
Thank you. Is there information about the defendant?
For the
¿Y hay
defendant,
información del acusado?
for the defendant, Your Honor, we located criminal history of Federal, California, New Mexico.
Y para el acusado encontramos antecedentes penales de California, Nuevo México y de Estados Unidos.
One misdemeanor with no conviction.
Un delito menor sin condena.
4 misdemeanor FTA bench warrants.
4 delito menor órdenes de arresto por falta de comparecencia.
5 felonies with 1 conviction. That was robbery, 2nd degree, 2002 to California.
5 delitos mayores con una condena para robo en California en 2002.
And we located a case pending with Judge Rogers for aggravated battery, great bodily harm, aggravated assault, misdemeanor battery.
Y hay un caso pendiente ante la juez Rogers para agresión con agravantes y agresión con lesiones con agravantes. Background, what was the third charge, please?
Misdemeanor battery.
Y agresión en nivel delito menor.
The defendant is currently booked on a violation of conditional release hold, and there's a conditional release hearing scheduled for February 16th.
Y actualmente está detenido en un quebrantamiento de condiciones de libertad y tiene una audiencia el día 16 de febrero.
And per the PSA, score the letter P, PML 4.
Y para el nivel de observación, el PSA es PML4.
State, what is your position?
¿La fiscalía qué opina?
The state requests ROR with standard conditions and supervision at PML4.
La fiscalía pide libertad bajo palabra con las condiciones estándares y PML4.
Defense, what is your position?
¿Y la defensa qué opina?
Judge, I would request supervision at PML 3. It sounds like there's only one failure to appear that was located.
Su señoría, yo pido PML3 porque parece que nada más había una instancia de falta de comparecencia.
Okay, I won't require a monetary bond.
Bueno,
Today,
entonces,
and I will authorize you to be released with pretrial supervision. You will be held on the other pending case, however.
entonces voy a dejarle libre sin fianza. Voy a ordenarle a servicios anteriores al juicio, pero va a estar detenido en el otro caso.
While the case is pending, obey all laws and keep the court notified of your address.
Mientras está pendiente el caso, tiene que acatar a toda ley y decirle al tribunal si cambia de dirección.
No firearms or other dangerous weapons.
No puede portar armas de fuego ni armas peligrosas.
No alcohol or illegal drugs, and stay out of liquor and cannabis establishments.
No puede tener bebidas alcohólicas, ni drogas ilícitas, ni cannabis. No puede entrar en ningún sitio donde se vende cannabis.
Keep the court notified of your address.
Tiene que notificar al tribunal de su dirección en todo momento.
And stay in contact with your attorney.
Y tiene que estar en comunicación con su abogado.
And immediately upon your release from custody, you'll report to pretrial services.
Y inmediatamente que salga de la cárcel, tiene que reportarse con servicios antes del juicio.
That's located at 4th and Roma on the 2nd floor.
Está en la calle 4 o 4th y Roma en el, sorry, Your Honor, which floor?
Second.
En el segundo piso.
And the phone number is listed on the order that you will sign.
Y el número de teléfono va a estar en el papel que usted va a firmar pronto.
The deadline to have a preliminary hearing or a grand jury in this case is April 16th.
Y la fecha límite para tener una audiencia preliminar o una audiencia de gran jurado es el 16 de abril.
You'll be given a preliminary hearing date earlier in April.
Y a usted le va a dar una fecha para una audiencia de evaluación preliminar a principios de abril.
Any questions, sir?
¿Tiene alguna pregunta, señor?
No.
No.
Thank you. You can have a seat.
Gracias. Puede tomar asiento.
Lorenzo Rodriguez Safarain.
Lorenzo
FR
Rodríguez Satarian. Sorry, Your Honor.
You're fine. FR 2022-626.
FR 2022-626.
Evan Durek for the state.
Kevin Durek para la Fiscalía.
Griffin Hardy for Mr. Rodriguez Satarain.
Griffin Hardy para el señor Rodríguez Satarain.
Mr. Rodriguez Satarain has been advised of the pending charge as well as the maximum penalty and waives the formal reading of the criminal complaint.
El Satarian sabe cuáles son los cargos en su contra y las penas máximas posibles y renuncia la lectura de cargos formal.
And there is no probable cause challenge at this time.
Y no hay ninguna oposición a motivo fundado en este momento.
Is there information about the defendant?
¿Y cuáles son los datos sobre el acusado?
For defendant, Your Honor, we located no misdemeanor or felony history.
Para el acusado no encontramos ningunos antecedentes penales de delito menor ni de delito mayor.
We located one active domestic violence TRO with the same alleged victim that was filed today.
Y encontramos una orden de alejamiento de violencia intrafamiliar con la misma supuesta víctima.
And there's a domestic violence hearing scheduled for March 17th.
Y hay una audiencia de violencia intrafamiliar programado para el 17 de marzo.
For the PSA, Your Honor, scored the letter A as an apple.
Y para el nivel de PSA es la letra A.
State.
¿La fiscalía qué opone?
State requests ROR with standard conditions, no contact with the victim or anyone who may testify, and no return to the location of the incident.
La fiscalía pide libertad bajo palabra con las condiciones de libertad estándares, que no tenga ningún contacto con la supuesta víctima ni con cualquier persona que puede declarar en el caso.
Does the defendant have someplace else to reside?
Defensa, ¿el acusado tiene algún otro sitio para vivir?
He does, Your Honor. He can stay with family.
Sí, su señoría, él puede quedarse con familia.
Who will he be staying with?
¿Y con quién va a estar viviendo?
Con mi tío.
His uncle.
Con, with his uncle, con su tío.
And where is that at?
¿Y dónde está?
505 Charleston, Albuquerque, Nuevo México.
505 Charleston, Albuquerque, New Mexico.
Since the defendant has an alternative place to live, and the state is requesting his release, I'll release him on his own recognizance. So that means you don't have to post any kind of bond. But while the case is pending, you are not allowed to go to the 9719 Western Avenue address.
Y entonces, debido a que el acusado tiene donde ir para vivir, voy a aceptar la recomendación de la Fiscalía de dejarle libre bajo palabra, y eso quiere decir que no tiene que pagar una fianza, pero no puede regresar a la dirección de 9719 Western Avenue.
You're not allowed to have contact with Sandra Pacheco, Gardea, or Eva Pacheco.
Y no puede tener ningún contacto con Sandra Pacheco Rivera. Your Honor, did you say Eva Rivera?
Yes, Eva Pacheco.
Ni Eva Pacheco.
Or anyone else who might be a witness in the case.
O cualquier otra persona que podría ser testigo en este caso.
You understand?
¿Usted entiende?
Lo tengo entendido.
I do understand.
And I found the other name, Oscar Pacheco. No contact with him as well.
Y Oscar Pacheco no puede tener ningún contacto con él tampoco.
Okay.
Okay.
No firearms or other dangerous weapons.
No puede portar ninguna arma peligrosa ni ninguna arma de fuego.
No alcohol or illegal drugs.
No puede tener bebidas alcohólicas ni drogas ilícitas.
Bad or liquor establishments and cannabis establishments.
No puede entrar en ningún establecimiento donde se vende bebidas alcohólicas o cannabis.
Stay in contact with your attorney and keep the court notified of your address.
Tiene que estar en comunicación constante con su abogado y tiene que notificar al tribunal si cambia de dirección.
You understand the conditions, sir?
¿Usted entiende las condiciones, señor?
Sí, perfectamente.
Yes, perfectly.
Okay, thank you.
Bueno, gracias.
I think those are the only two cases that we required the interpreter's assistance on.
Thank you, Your Honor. May the interpreter be excused?
Yes, thank you.
Thank you.
Nicholas Lopez, FR 2022-629.
Kevin,
Donna,
you're
did
right.
you say Christopher Lovato?
No, I said Nicholas Lopez.
Griffin Hardy for Mr. Lopez, who has been informed of the pending charges as well as the maximum penalties and waives a formal reading of the criminal complaint. There is no probable cause challenge at this time.
Okay, the state has filed a motion to preventatively detain. So the case will be transferred to the district court. And the 10-day date is March 1st. So the case will be transferred over to a district court judge who will make a determination if you will be released and what those conditions will be if the judge decides to release you. Do you have any questions, sir?
No, ma'am.
Okay, thank you.
So by March 1st, you're up.
Yes. You'll have a preliminary hearing by that date. Anthony Sandoval, FR 2022-632.
Kevin Durek for the state.
Griffin Hardy for Anthony Sandoval, who has been informed of the pending charges as well as the maximum penalties, waives a formal reading of the criminal complaint at this time, and there is no probable cause challenge.
So the state has filed a motion to preventatively detain in this case. So the case will be transferred over to the district court, and the district court judge will make a decision about what, if any, conditions of release they will impose in the case. The 10-day date is March 1st for the preliminary hearing or grand jury to be held. Do you have any questions, sir?
Do you have any questions?
No, ma'am.
Okay, you can have a seat. Thank you. Is Christopher Lovato there yet?
Here he is, Your Honor.
For Lovato, FR 2022-628.
Kevin Durek for the state.
Griffin Hardy for Christopher Lovato, who has been informed of the pending charges as well as the maximum penalties. At this time, waives a formal reading of the criminal complaint, and I do not have a probable cause challenge today.
Okay. So this is also a case where the state has filed a motion to detain. So the case will be transferred over to the district court for the district court to make a determination about what, if any, conditions of release they will impose. And the 10-day date is March 1st. Thank you, sir. Okay, I think it's Jet Doe. FR 2022-621.
Kevin Durek for the state.
Griffin Hardy for Mr. Doe, who has been advised of the pending charges as well as the maximum penalties, and waives a formal reading of the criminal complaint today. Judge, I do have a probable cause challenge of sorts, which is that there are 3 counts of felony criminal damage to property. I think there is probable cause for 1 count, but I'm not sure where the 3 counts are coming from.
My criminal complaint has 2 of them crossed out, and instead it has criminal damage over $1,000, concealing identity, and resisting or refusing an officer as the 3 charges.
That may have been amended then after I looked at it.
Okay. State, is that what you're intending, is the 1 count?
Yes, Your Honor. It looks like he just didn't, he added the statute cites for those other 2 charges, but then left 3 statute cites for criminal damage. So I think that's why it just got entered that way. It's supposed to just be 1 count of criminal damage.
Okay. Is there information about the defendant?
Your Honor, background was unable to locate any information on the defendant. There was no fingerprints to get FBI numbers, and Jet Doe was, this is the only case that came up, Your Honor. So nothing from background on this case, Your Honor.
So was he fingerprinted?
He was fingerprinted, but there was no FBI number associated with, or has not came back from the database, Your Honor, as of 12:30.
So basically there's just no information available on him. Is that correct?
Not currently, Your Honor.
State, what are you requesting we do?
The state would request an ROR with standard conditions.
So, background tell me his fingerprints have not been, what would be the right word? Have not been matched or identified or find a number? Background, could you hear me?
Yes, Your Honor. So I'm doing some more research on OMS.
Okay, I was just
So-
asking, I didn't know if you heard. Thanks.
So currently, Your Honor, looking at the detainers, so the defendant still has not been printed at NBC, and that was commented yesterday at 8 p.m. or 8 a.m. Sorry. So the defendant has not been printed, and we in background have no information as to who the defendant is. Therefore, we were unable to locate any criminal history, NCIC or Odyssey, Your Honor.
So, Jill, can you tell me, do you have any information about when we might be able to get his fingerprints?
Your Honor, I'll make sure that he gets fingerprinted, in the next couple of hours.
I'm reluctant to order a release on somebody when I don't know who he is. My ability to ensure that he appears in court, again, is at least somewhat dependent on the fact of identifying him and knowing who he is.
Judge, what I can inform the court is that our staff did speak with Mr. Doe earlier, and he did state that that is his actual name. If the court would like, I could call the podium and talk with him myself right now. If you need more information, maybe I can get something that way.
Sure, why don't you go ahead and give him a call?
Okay, thanks.
Your Honor?
Yes.
We called the IDO to get him fingerprinted and they can do it. We'll take him over there to get it done.
Thank you.
Your Honor, if Jeto is the name, I have the name and date of birth. I can also run it via NCIC, see if anything, well, I can check.
I'm just confused why that wasn't already done, both of them, why his fingerprints weren't taken and why we didn't interview him and try to find out something prior to it being said today. It looks like he's been jailed out 36 hours, but I don't know how things are proceeding.
So he was uncooperative with jail staff for intake's interview. So we didn't get to interview him. And doing a scan of NCIC, I don't see anything based on that name and date of birth, Your Honor, based on the NCIC that we ran.
Judge, I do have a bit more information on Mr. Doe.
Okay.
What I learned from just speaking with Mr. Doe is that it sounds like he experienced a fairly significant head injury when he was taken into custody or during this incident. And he does not necessarily know who he is what he's representing to me. So I think it might make sense to get him fingerprinted and see what turns up from that.
That seems to be prudent. So what I'm going to do then is reset it for tomorrow, and hopefully we can get some more information. And then perhaps we can find out why nothing happened the last 36 hours to already find that out. But we'll reset it for tomorrow. And also, if he's reporting at a significant head injury and he doesn't know for sure who he is, perhaps some medical attention would be appropriate as well. Thank you. Okay, Jacob Bowers, FR 2022-606.
Kevin DeReich for the state.
Judge Griffin Hardy for Mr. Bowers, and it was my understanding that a noli was filed in this case earlier today.
That's correct.
No one told me, so State, have you dismissed this case? Do you have any-
This is ending 606, correct?
Jacob Bowers,
Jacob
yes,
Bowers.
FR 2022-606.
That's correct, Your Honor. We filed an only in that case.
When did you file that?
Today, and I'm
Okay.
sorry, I have to actually
That's
open
fine.
the case in Odyssey to see a timestamp.
All right, Enrique Chavez, FR 2022-622.
Kevin DeReich for the state.
Griffin Hardy for Mr. Chavez, and Judge, I believe the state filed a motion in this case to amend count 2 to a misdemeanor and reset for a custody arraignment. So I would ask the court to grant that motion and reset this tomorrow morning.
And don't have that motion either. There's a disconnect, I guess, this afternoon. It does look to me like the last case was taken off the docket, but sure what happened in the interim. This one is Enrique Chavez. So the state, what is your motion? To lower the criminal damage? Oh, it's
Yes.
not for me.
That's correct.
One page of it. Let's see. Amend count 2 to criminal damage of property member over 1,000 to criminal damage of a property member set for a bond arraignment. And the defense agrees, is that correct?
Yes, I would stipulate to the motion.
Okay, so what the clerk is asking me to do is to go ahead then and proceed with the misdemeanor first appearance instead, and to make sure that he's advised of the charges, his rights and penalties, and to establish conditions of release now, based on that amendment. Are the parties okay with that?
It's fine with the state.
That's fine with defense, and he has been advised of the charge and the amended charge, as well as the potential penalties. I would request an ROR as the conditions of release.
Background, do you have information about him?
For the defendant Chavez, Your Honor, we located 4 misdemeanors with 1 conviction. We located the case pending with Judge Martinez for DWI open container, driver on a rope license, leaving the scene of an accident. Currently booking $1,000 cash or surety, failure to appear, bench warrant, and a violation of condition release hold. There's a condition release hearing scheduled for February 16th at 10 in the morning. 6 bench warrants, 2 of which are for failure to appear. The defendant is booked on a domestic violence case with Judge Valdez. It's a no bond, failure to appear, 2 failed to comply bench warrants, and 2 $234 cash only failure to pay bench warrants, as well as a violation of conditions of probation hold. And there's also a conditional release violation hearing scheduled for February 16th at 10:30 a.m. No felony history was located, and we did locate 1 active domestic violence TRO with the same alleged victim. That was inactive with the same alleged victim, and that was dismissed August of last year. Per the PSA, Your Honor, there was a violence flag, and it was TPML3.
Okay.
The state requests ROR with standard conditions, pretrial supervision, no contact with the victim or anyone else who might testify, and no return to the location of the incident.
Just requesting an ROR still. Is there anything else you wanted to say? Defense?
No further from me, Judge.